Hi everyone, my name is Jonathan Yuen. I'm a partner at Rajah and Tann and head of the firm's Employment Disputes Practice Group. Today, we're here to talk about performance improvement plans and how these plans impact the employment structure in companies. Well, interestingly, in Singapore, there is no judicial or statutory definition for what a performance improvement plan is, nor are there any official guidelines from the Ministry of Manpower. However, most HR professionals and lawyers who practice employment law will agree that a PIP generally consists of 4 separate portions. The first bit would be the identification of the areas of the performance gaps in an employee's conduct or performance that needs to be fixed. Number 2, the plan then proposes some remedial or rectification steps that the employee needs to take. Number 3, it sets out a time period for which the employee has to complete this rectification by or to show improvement by. And number 4, it sets out specific and clear consequences of what happens when the employee meets or does not meet the milestones that have been set for him or her within the PIP. A PIP, while it is part of the employment agreement, is actually treated as a separate component. So let me explain how this works. Essentially, when an employee is told that they're put on the PIP and certain performance milestones have been set for the employee is now under a fresh obligation to meet these milestones. Now, if the employee does not meet these milestones, then the company, assuming it has already set out very clearly what the consequences are, the employee will have to face those consequences. Put simply, when a company institutes and offers a PIP program to an employee, the company is now obligated to complete that program, the PIP process, and the entire time period for which the PIP has been offered to the employee. PIPs generally run anywhere between 2 to usually no more than 6 months. The short answer has to be yes. However, in deciding whether or not to extend the PIP, it has to be on the basis that the employee has not hit certain milestones, and on top of that, the company is interested in giving the employee a little bit more time to try to meet these milestones. The next question then is, how long can a PIP be extended by? It should be extended by no more than half the time period, and at the very latest, no more than an additional cycle of the PIP that was originally given to the employee. Conversely, can we reduce the period of a PIP? The short answer is no, because the PIP period has already been decided and entered into as a separate agreement to give the employee that amount of time to improve. And hence it would be fundamentally unfair to the employee if, prior to that pre-arranged time, the company unilaterally decides to shorten the process and to jump to a premature conclusion. Of course, it can be amended, but it has to be amended with the mutual consent of both the employer, the supervisor, as well as the employee involved, to ensure that both sides agree as to what these new milestones or new objectives ought to be. A PIP can be breached by either the employee or the employer. An employer can breach a PIP by, for instance, unilaterally changing the objectives and the goalposts set by the original PIP without the consent of the employee. On the part of the employee, a breach of the employee may sometimes play out as follows. The employee is given a certain task to perform or to try to achieve a certain milestone or to try to achieve certain objectives, and the employee refuses to take up that task or refuses to perform that task. And the very act that the employee refuses to comply with the threshold requirements of the PIP means that the employee has breached the PIP. The other way of looking at breach from the employee's perspective is if the employer gives the employee a certain task and a certain standard to hit, and they just can't hit that standard, and that would also constitute a breach of the PIP. Well, the short answer is no. This is because the company is entitled to ask an employee to comply with normal, lawful directions in the course of work, such as to attend events or undergo internal or external training. And this discretion obviously includes being placed under or being subject to a PIP. Now, if the employee refuses to be put on the PIP, that would clearly amount to a breach of the employment agreement, and it may be open to the company to consider that the employee has repudiated his or her employment agreement by refusing to comply with a reasonable and lawful direction. The company may then choose to dismiss the employee for cause if this scenario is provided for, or to dismiss the employee with notice. Two immediate problems come to mind. The first is where the PIP fails to have objective measures of performance or benchmarks for improvement, and the second is when there is no independent assessment of performance. In the first instance, it is unfortunately quite common that remarks such as "Mr. X is not a team player" or "Miss A does not show sufficient initiative in her work," that these phrases continue to appear on PIP documentation. These types of criticisms are too vague to be acted upon, and more importantly, will open the organization to litigation risk. A hostile employee will almost certainly question how the organization came to that particular criticism or conclusion. If he or she hasn't already run off to seek legal advice, or worse still, made a complaint to the Ministry of Manpower for being discriminated against or being retaliated against. As such, we always advise that clients properly document the performance of the employee and be ready to discuss specific examples of the conduct that has been identified to be problematic. For instance, the employee should be told, "In 5 team meetings during the last quarter, you only made 1 proposal, whereas the rest of the team all made at least 5 to 7 proposals each." This type of feedback is at least more specific and provides a good basis on which a conversation can be had with the employee identifying the conduct to be rectified. In the second instance, it's pretty worrying when the supervisor who recommends that an employee be put on the PIP ends up also being the sole assessor of that same employee. Imagine how you would feel if you were that employee on the PIP. If, for whatever reason, the person recommending the employee to be put on the PIP must also be an assessor, then it would only be fair that there are also other senior stakeholders from HR, legal, or other business units to also have a say in the assessment of the employee on the PIP. This is one of the most contentious parts of the PIP process, where the employee feels that the PIP is nothing more than an elaborate show of going through the motions when the decision has already been made to condemn him or her, and that he or she has not been given a fair opportunity to prove himself or herself. A surefire recipe for litigation and complaints to the Ministry of Manpower. Employers have to be extra careful, especially after the 1st of April 2019, because of the introduction of the tripartite guidelines on wrongful dismissal. If you put an employee on a PIP, and for instance the employee has passed the PIP, then the employer cannot, within let's say 2 months or 3 months after the PIP at the end year review, suddenly take the position that the employee has performed so badly that they want to terminate the employee for poor performance. Similarly, it would amount to wrongful dismissal if, within the context of the PIP, the employer breaches the terms of the PIP such that the employee has been set up to fail. And in those instances, that would amount to wrongful dismissal under the new MOM guidelines as well.